The Supreme Court concluded historic arguments on Obamacare last week. Today we're going to be talking about it on Faith and Freedom. I'm Matt Staver, founder and chairman of Liberty Counsel. Joining me is Matt Barber, vice president of Liberty Counsel Action. Matt, the Supreme Court concluded 6 hours over 3 days of oral arguments on the Obamacare case. And by the end of last week, they also got together. We don't know what the vote is, but they began with the Chief Justice, moving all the way down to the most junior justice, in which each one of those justices gave their vote and the reason for their vote. And now, this week, the decision is actually in the writing phase, and the decision will come out sometime later this year by the end of June. And the first day of the oral argument was on this so-called Anti-Injunction Act. It looks like from the justices' questions and comments that they're not going to stumble over that. They're going to get right to the very merits of the case.
Yeah, it was interesting to watch. There was even laughter in the courtroom at one point when the attorney arguing on behalf of Obamacare found himself in the untenable position of having to both call the penalty for not paying the insurance premiums associated with Obamacare, the individual mandate, both a tax and a penalty. So the federal government here is in this position of having to call it both a tax and a penalty, and the justices that did not get past the justices, even Justice Stephen Breyer, seeming to bristle at the notion that the government wants to have its cake and eat it too here.
Yeah, and of course, this issue that was before the Supreme Court on the very first day of argument for 90 minutes argued before the court, when arguments are usually 1 hour for the entire case, 30 minutes aside, was an issue that our case, Liberty Counsel, put front and center right before the United States Supreme Court in the case of Liberty University versus Geithner. It was in that case that I argued at the Fourth Circuit Court of Appeals, and the court issued a 2-1 decision. Two judges in that case found that the Anti-Injunction Act applies. One judge gave a long dissent saying it did not apply. We, of course, argued that it did not apply. The Department of Justice did not believe that it applies. We filed two important briefs at the United States Supreme Court, one of them specifically on the Anti-Injunction Act, saying that it doesn't apply. I believe that a majority, if not all 9 justices, for one reason or another, will ultimately find that the Anti-Injunction Act does not apply, which is significant because if it does apply, then you couldn't reach the merits of the case, the individual mandate, or anything else with regards to the mandate until you actually paid the penalty and or tax, however you want to argue it. And that wouldn't be until sometime 2014 and thereafter. So in other words, a lawsuit right now would be premature. And the reason for that Anti-Injunction Act is an old law. And essentially, whenever a tax is at issue, in most cases, not all, there's a few minor exceptions, but in most cases involving the imposition of a tax, you have to first pay the tax, ask for a refund, you disagree with the refund for whatever reason, and then you file suit regarding the refund, or you file suit regarding the underlying law that gave that ability to tax. And since the penalty doesn't happen until sometime after 2014, which would mean you couldn't file suit until sometime thereafter.
Yeah, and that's the issue. Then this would be pushed back until 2015. The Obama administration, they want to get this thing, the water under the bridge, get this behind them, and so that the implementation can take place smoothly and as smoothly as this debacle can possibly take place.
That's right.
In 2014.
2014 would be when the law would go into effect with regards to the mandate. You either have insurance as an individual or you pay the penalty. Obviously, that wouldn't be imposed until 2015 on your income tax, so that's the year that you would probably be first able to file suit. Now, it took 2 years, and that was quite fast to get this to the United States Supreme Court, from March 23, 2010 until March of 2012 when the law was signed versus when it was argued. So you're talking about another 2 years. So you're looking at 2017 before you'd actually get before the United States Supreme Court again, as opposed to 2012. So that's about a 5-year difference. And that's what some people would like to see. But the interesting thing is that even the Department of Justice doesn't believe it applies. We argue that it doesn't apply for several reasons. First, this is a penalty by the statute itself. It is not a tax. There are taxes that are imposed in this law in other places, but not for the mandate. The mandate is clearly a penalty. That's what the statute says. Secondly, it doesn't apply in all cases, especially when the government can waive it, because there's exceptions to this, and the government has chosen to not apply it. The statute doesn't apply it, and it doesn't apply to the states anyway.
Well, in lies the problem for the government here is they have to argue that it is both a tax and it's not a tax. They're arguing it's not a tax so that the Anti-Injunction Act will not come into play, but they are arguing it is a tax because if it's a penalty, the bar is much higher in terms of constitutionality. If it's just a tax, then they can invoke the taxing power.
They look at the taxing and spending clause.
And spending clause, and that gives them much broader leverage to impose the individual mandate is the theory. But during the arguments, even Justice Breyer, even Justice Kagan really took Attorney Robert Long to task. Breyer saying, now here Congress has nowhere used the word tax. He points out that nowhere in this legislation is it called a tax. And he says, and so why is it a tax now? And he went on to add that they called it a penalty and not a tax for a reason. They wanted it to fall outside of that. So he was clearly showing that he had an issue with what the
and even legislative intent. It is very clear because before they used to call it a tax in some of the previous versions of the law, both on the House and the Senate, and then they changed it and they removed the word tax and instead put in penalty, and it's more of a regulation as opposed to and it's a penalty for not being regulated as opposed to a tax. It doesn't really raise revenue. For example, a tax is designed to raise revenue. While certainly if a lot of people didn't have the insurance, you'd have some funds from the penalty. The fact of the matter is, if everyone had the insurance, you would have no revenue-raising mechanism. And think of any other tax like that where you'd have no revenue-raising mechanism if you refused to be regulated. So there's a lot of reasons, and it can be complicated. The bottom line is that our case, Liberty University versus Geithner, teed this case up, and it was what ultimately was the reason for the court addressing this because of our Liberty decision. I think that the majority of justices, may well be 9, will rule that the Anti-Injunction Act does not apply, meaning they'll get right to the merits of the case and they'll go right to the heart of the issue of the individual mandate.
Well, and that is the real focus. That's where the real debate lies on this, because what does Obamacare do? As we've said over and over again on Faith and Freedom and elsewhere, it for the first time ever, it requires individual taxpayers to engage in commerce, to affirmatively purchase a good or a service, in this case, government-approved insurance, and this is unheard of. So if the Commerce Clause, if the Taxing and Spending Clause, if this unlimited power falls underneath this umbrella and gives the central government this kind of power, then there is literally nothing that the federal government cannot control. No aspect
That's right.
of your
And
life.
it's actually even broader than requiring taxpayers, but it requires every single citizen who is law-abiding, except for minor exceptions, to have insurance or pay a penalty. The only people who are essentially accepted are people who are incarcerated, or those who are part of a Medi-Share program,
or
that were in existence at a certain period of time,
or the many millions that live here illegally,
or illegal aliens.
Yeah.
Those are essentially the
so
three
it's
categories.
a requirement of citizenship.
It is a requirement of lawful citizenship.
Yeah.
So if you are a law-abiding, not incarcerated, not illegal citizen, you're under this particular regulation, which is staggering. Just by virtue of the fact that you are a United States citizen, Congress therefore will regulate you, and Congress will force you to buy a particular health insurance product that may vary from year to year or even month to month based upon the whim of the current Health and Human Services Secretary, Kathleen Sebelius.
It's the trial of the century.
This is a very important case. You can go to Liberty Counsel's website for more information, lc.org. You can actually look at our briefs, the 2 briefs that we actually filed at the United States Supreme Court. One of them was on the what is called the Anti-Injunction Act, and the other is on the core issue, and that is the individual mandate. We'll talk about Obamacare more on this program this and next week as well, because this is an important case. They gathered at the end of the week to make a decision. They're in the writing phase now, so we ask that you pray for this case. Go to Liberty Counsel's website and ask for our bumper sticker, Lord, Deliver Us from Obamacare. We want you to display it, but we also want you to pray for this case and for America. Visit lc.org, and you can also sign up for our Liberator and our email right there at lc.org.